Okay, it is 1 o'clock. The Alamance County Board of Elections is back in session. We are getting ready to have a preliminary hearing. And given the allegations in the petition, I would ask the board to recuse me from deliberations in this matter, in fairness of all parties present.
So move. Second.
Thank you. Sitting in the chair will be the secretary.
We vote on it.
All those in favor of the motion signify by saying aye.
Aye.
Opposed signify by saying no. Motion carries. And the next person on will be the secretary, Noah Reed, who will sit in for the chair. Thank you.
Thank you, Dr. Yarborough.
Just in the chair.
So I'll now call the meeting to order November 9th at 1 p.m. at Medcalf Building. The meeting of the Board of Elections. This is in this meeting, we will conduct a preliminary hearing and also conduct a recount for the town of Green Level. Everybody has the copy of the agenda. Are there any additions to the agenda? Yep. I have a question, Director Holland. We have talked about considering early voting sites and dates as a part of this agenda.
Yes.
Seems like we have a pretty full agenda. Should I ask the board, would it be appropriate to ask the board whether we should consider that at a later time?
Certainly, you can certainly ask to table that to the next meeting or a meeting at another date to be less specific.
Can I get a motion on that?
So move. Second.
All right. So we will move that to our date and time to be determined. All right. So number 4 is removed from the agenda. Can I get a motion to approve the agenda?
So move. Second.
All those in favor?
Aye.
All those opposed? Motion carries. So we will, that moves us to item number 2, the preliminary hearing, where we will be considering an elections protest for the town of Green Level. You have in your green packet, green folder, the information that has been submitted in this protest. The protest has been submitted by Ida Kleiner and Stephanie Enoch. This is for the November 2021 town board election. And there are several elements to the protest, and I guess we will take them one at a time. The first element that in your packet concerns the staff members of the Board of Elections itself. I will, there's about a paragraph here that I think has the main issue at hand for this part of the protest. And I will just read that out loud. The first violation, everybody we're on section B, page 1. The first violation appears to be misconduct by a representative of the Board of Elections. Representative that is a staff member, I believe. So not to be confused with a board member. When Ida Kleiner entered the Board of Elections in Graham, North Carolina on Wednesday, July 14th, 2021 to inquire about running as a candidate for the town council in Green Level, North Carolina, Ms. Kleiner asked if anyone was running, and the representative said no. Again, that's a staff member. Ms. Kleiner mentioned to 2 Board of Elections members that she was considering running for a seat on the town council. Ms. Kleiner decided to go back on Friday, July 16th, 2021, approximately 8:15, to file her paperwork for a seat on the town council. Just as the other Board of Elections representative was about to take Ms. Kleiner's paperwork, another Board of Elections representative interjected and said, I called Michael Trollinger, council member Green Level, and I told him to send some people down after you came in on Wednesday. It appeared that Michael Trollinger had requested for the Board of Elections to inform him if Ms. Kleiner filed her paperwork to run for town council. Mr. Trollinger is a Republican, and he knew that Ms. Kleiner had been affiliated with the Democratic Party. Ms. Kleiner was informed by the Mayor Pro Tem Howard that Mr. Trollinger consistently inquired about Ms. Kleiner's interest in running for town council back in May. As per the Code of Conduct, GS 163, this Board of Elections representative interfered with the elections process. The election process, clearly this employee did not remain impartial and acted as an informant to Michael Trollinger regarding Ms. Kleiner's decision to run for a seat on the town council. Included in this protest submission is a photograph of the Board of Elections representative that stated she had called Michael Trollinger. So with that, I will open up for discussion. The other board members?
Couple things. If you look down about the middle of that paragraph, you'll see that it says it appeared that Michael Trollinger had requested the Board of Elections to inform him. Well, appeared is not actually doing, in my opinion. It has to be yes or no. The other thing is this occurred back in July. Why hasn't a complaint been filed prior to then? Why wait until now? Why not file it when it happened? If they felt like there was something going on and there was a complaint. So that I had concerns about that also. And it is my understanding, and I could be corrected, Director, if I'm wrong, that these small municipalities, i.e. Green Level, Ossipee, Village of Alamance, when candidates are not actually filing for office, there will be calls made by staff members at the Board of Elections to say, hey, we don't have any candidates, or maybe we just have one or whatever, just to let them know. Now, as far as calling a board member, that person was an active board member. My understanding is that Mr. Brown, there was an attempt to call him on several occasions, and he just was not available. So that's what I have to say about that.
I would like to ask the attorney just to clarify. I believe there's 2 grounds on which we have to agree for this to move from a preliminary hearing to a full hearing.
Correct.
Can you please let us know what those are?
So for each allegation that is alleged in the complaint, there is 2 steps that have to be confirmed to get to the full hearing, at which evidence other than the content of the application or complaint can be submitted and heard by the board. So that is what we're doing here at the preliminary hearing. So today you're deciding 2 things. First, whether the protest demonstrates probable cause, and 2, whether it is substantial, or whether the complaint substantially complies with the filing requirements.
That second question, I believe it is my impression that the filing requirements were met with this protest.
I don't think that's in dispute.
Okay.
No.
The second question is, do we find probable cause? And can you define probable cause for us?
Yes, sir. The state defines probable cause in this situation to mean a non-technical probability that incriminating evidence is involved. Probable cause does not require a showing that the protest be correct or more likely true than false. Rather, it is a relatively low bar that simply indicates the possibility of a protest truthfulness.
And I believe there is a point at which it has, I think the phrase was outcome determinative.
Yes, sir. If you give me one moment, I can pull that up.
I think that's in.
From the handout from the state, it says that the county board will review the filed protest and consider whether it establishes probable cause of an outcome determinative irregularity, violation of law, or misconduct.
Irregularity, violation of law, or misconduct.
That is outcome determinative.
Could you repeat those three things one more time?
Yes, sir. The county board will review the filed protest to consider whether it establishes probable cause that I previously defined for you of an outcome determinative irregularity, violation of law, or misconduct.
So my thoughts are that with the being an outcome determinative, for this allegation, whether somebody's running or not is public knowledge. Whether somebody else encourages someone else to run or not, I don't think would violate law to the point where it would be outcome determinative. And so at least my impressions of what these allegations are on allegation one, I don't think would meet the standard for probable cause.
I agree.
Any other discussion on that?
It's my impression that the Board of Elections office routinely will contact a party to find out if they will have a candidate running from that party in the election. And that inquiry is not partisan in that it's not working for a particular party or not, but is in the interest of making sure that a candidate, if there is going to be a candidate, will be running, but not in order to put forth or to work on the part of a particular party.
All right. Any other discussion? So,
Actually, do we need to make a determination on each allegation as whether or not there's probable cause?
That would be the best method.
Correct.
Yes.
So we need to vote on each allegation
Okay.
after discussion.
there is no more discussion. Hearing none, I will entertain a motion to pursue the initial allegation we've discussed.
I move that this first allegation does not meet the criteria for probable cause, or it does not meet the requirement for a probable cause.
Second.
Any other discussion? Hearing none, I will, all those in favor of the motion signify by saying aye. All those opposed? Passed unanimously. So we move to,
Mr. Chairman, before we move on, can we just vote on procedure just for the record?
procedure.
Whether whether the applicant completed or
Yes,
substantially
yes.
complied with the filing requirements of the
Yes,
complaint.
thank you. I will entertain a motion that the election protest was timely, was filed in a timely way and with proper information provided.
So moved.
Second.
With the motion, and those in favor of the motion signify by saying aye.
Aye.
Those opposed? Passes unanimously. So in the third paragraph of section B, page 1, an additional violation is has been posed, and I will read that aloud. Additionally, a violation occurred when the Board of Elections member called a sitting town council member of an opposing, well, wait a minute,
That's part of it.
that's part of the person. Okay.
Yes, sir.
We'll move to the fourth paragraph. Additionally, there was a candidate forum at the Green Level Town Hall on October 14th, 2021 at 6 p.m. During the forum, Dorothy Yarborough, Chair of the Board of Elections, conducted a presentation on write-ins. The presentation proves contrary to the Board of Elections employee protocols. Mrs. Yarborough instructed the electorate of the town of Green Level to write in Hosea McBroom's name in the write-in section on the ballot. She did not act as a neutral party in instructing the electorate on the process of voting for a right candidate. She specifically provided the exact spelling of Hosea McBroom's name and informed the residents not to use his nickname and just to write. And she spelled out exactly what she instructed. Her actions constitute a violation of GS 16339 and diminish the integrity of the Board of Elections. Then the general statute is quoted. And I'll read the main idea there. No individual subject to this article shall limitations on political activities of Board of Elections members. No individual subject to this article shall make written or oral statements intended for general distribution or dissemination to the public at large, supporting or opposing the nomination or election of one or more clearly identified candidates for public office. We'll continue. The protest includes General Statute 16340. This violation may be grounds for removal. A violation of this article may be a ground to remove a state board of elections member or a county board of elections member under GS 16322C. It goes on to say, additionally, at the candidate forum, Ms. Yarborough made a statement of an expression of opinion in a room. Well, that goes on to we'll call that the second half of the second allegation. We'll look at the first half first. Pertaining to the so I think one question here is the Board of Elections member conducted a presentation on write-ins. This presentation proves contrary to the Board of Elections employee protocols. Any discussion on that particular point?
The name in question, do we know how many votes write-in was that person received?
How many, the write-in candidate themselves, there were 103 write-in votes cast. 102 of those were for the candidate, the prevailing candidate.
I guess one question I have is, do we consider conducting a presentation on write-ins contrary to employee protocol in general?
I would say not. I think that the Alamance County Board of Elections does a proper thing when it tries to inform the electorate in how to exercise its constitutional right to vote.
Anyone else have an opinion on that before we move to the details?
I would agree.
That's it.
Okay, then we have Mrs. Yarborough instructed the electorate of the town of Green Level to write in. So this, just to be clear, this was a public forum. Ms. Yarborough instructed the electorate of the town of Green Level to write in Hosea McBroom's name in the write-in section on the ballot. In discussion, would we consider her actions to constitute a violation of GS 16339 and diminish the integrity of the Board of Elections? Discussion on that? Did she act as a neutral party in instructing the electorate on the process of voting, or did she not? Let me rephrase that. We are not determining whether or not the allegations are true or not, but or false. We are determining whether or not, if they are true, would they have an outcome determinative effect on the election. So if this part of the protest is true, would it have had an outcome determinative effect on the election? On page 2, there is a little more. Well, that's a slightly different issue, so we'll stick with this one before we move on.
Mr. Chair,
Yes, sir.
from the bottom paragraph of page 1 through about the middle, I would combine the third paragraph all the way down to the third paragraph of page 2, just for the purpose of the vote we're fixing to take.
Okay.
And I would make the motion, these are serious allegations, and certainly there are two sides to every story, but I just feel like this board has an obligation to hear the folks that, number one, made the allegations, and two, to hear Dr. Yarborough's defense. And I think we just need to go ahead and I'll make that motion that we go ahead and hear these allegations.
So go to a formal hearing?
Yes, go to a formal hearing.
No, it's never, I mean, obviously with us all being on the board together, it's never, but none of us want to be here listening, reviewing these allegations. But with somebody making these types of allegations, I think it's hard to say that it couldn't be outcome determinative. I mean, I just, with the writing candidate, I mean, I would agree. I think that we need to figure out exactly what happened.
And according to the definition of probable cause, it's a very low bar that needs to be met, and as to the definition.
According to the state, how they defined it in their handouts, it says, I'll read it one more time, but you're focused on the last sentence I'm going to read. Probable cause means a non-technical probability that incriminating evidence is involved. Probable cause does not require a showing that the protest be correct or more likely true than false. Rather, it is a relatively low bar that simply indicates the possibility of a protest truthfulness.
Yes. And we have sworn affidavits from those that are making the protest, and they're pretty serious. The one charge is pretty serious, so I think we need to hear it. And that's my motion, Mr. Chair, that we hear that.
Did we get a second on that?
Yes, I'll say.
Second. Any more discussion on that? All right. All those in favor of moving to a full hearing of the protests, signify by saying aye.
Aye.
Aye. Passes unanimously.
Now, Noah, will you continue to go through the other parts to determine what part of the protest you put, like on the first part you put, that it was no probable cause?
Okay.
Will you move on, will you go through the other accusations to say what's going to be in the protest, or can we do that?
Please,
To see what we can throw out or put in or
Okay.
whatever?
So that is,
just a clear record.
we don't have to do the whole thing. We can pick and choose what we believe
No,
needs to go to
no,
hearing.
if you could continue to go through the allegations,
Mhm.
so we can determine what is going to be decided at the hearing and what
Okay.
is not going to be decided at the hearing.
All right.
Instead of just focusing on what we just discussed with that writing candidate statement.
Okay. So can we, can you amend your motion specifying that this
Allegation 2.
allegation to be a part of the hearing?
I can. I'll amend the motion. Allegation 2 be a part of the hearing.
All right. Does that need a second?
So,
All right. All those in favor?
Aye.
All those opposed? Passes unanimously. All right. So we will now go to page 2, third paragraph. Additionally, at the candidate forum, Mrs. Yarborough made a statement of an expression of opinion in a room filled with electorate regarding an endorsement letter signed by Alderman Lawrence Slade and Phaedra Blackwell. She stated, "I want a copy of that letter because I don't believe they signed it, and I'm going to go down to see Mr. Slade." The representative from Evans City Council, Sean Ewing, was present when this conversation occurred, which appeared to be in violation of 16339 and possibly cost us votes. Solicit contributions for a candidate, political committee, or
I believe that is quoting the general statute previously cited.
All right, do we have discussion on paragraph 3, page 2?
Well, let me just say this. I know I had included that in my first motion. Therefore, I think it'd be appropriate just to go ahead and make the motion on this one that we hear it at the same time.
that was my understanding that was part of the
Yeah.
allegation in 2, so maybe I misunderstood.
Okay,
Yeah.
all right.
So that goes with the section that you voted on, is that right?
Yes.
Okay. So you're starting at pursuant to GS 16341 for the second
Yes,
one.
yes.
Third one.
Is everybody okay with that
Yeah,
clarification?
And that was my understanding.
Yes,
Okay.
that's what.
All right, I apologize.
That's okay.
All right, fourth paragraph, page 2. And this is the second allegation as we are considering it. I will read. It appears the Board of Elections precinct chair failed to monitor the buffer zone. Violation GS 163-654, where Patricia Jones brought 3 children with campaign t-shirts displaying "Growth for Green Level, Vote for Patricia Jones." And the children were inside the buffer zone for hours, running around and playing inside the buffer zone. Additionally, a few of Ms. Jones' campaign representatives were walking in and out of the building with campaign T-shirts on that displayed "Growth for Green Level, vote for Patricia Jones." Candidate Doris Richmond also crossed the line while speaking to a voter, and candidate Stephanie Enoch called her. Candidate Doris Richmond also crossed the line while speaking to a voter, and candidate Stephanie Enoch called her out on it. Once the precinct was set up, there appeared to be no monitoring of the buffer area nor any monitoring outside of the precinct to ensure that there was no interference with the candidate or voters coming into the poll. Electioneering was evident in the buffers area by Representative Patricia Jones' campaign. Please see the attached photos of electioneering within the buffer zone.
Ms. Aug, how many calls did we have from that precinct that day? Do you know? Did we have any?
I didn't take any myself.
Concerning,
Complaints about
I didn't take
the way
any
that,
either.
okay,
I think the issue is outcome determinative here. Children playing inside the buffer
Yes.
zone, even if it was alleged to be true, I don't think would reach the level of probable cause from an outcome determinative situation.
and I agree with it.
I would also like to add that monitoring the buffer zone continuously during election day, it would be nice if we had that kind of staff to have one person dedicated to every part of the election administration. But to be honest, it's the sort of complaint that we have every election at least several times. So it is not, I regret that if this happened, I regret that this happened, but again, outcome determinative. Is there any other discussion? Hearing no,
I was going to move to dismiss that claim.
okay.
Second.
All those in favor?
Aye.
Aye. That motion passes unanimously. And I think we move to page 3, paragraph 2, beginning on November 2nd. On November 2nd, election day, all candidates were at the poll for the final engagement with the electorate. Ida Kleiner was in the middle of talking to a voter when Councilman Michael Trollinger came over right next to her with an intimidating look and abruptly said to her, "Come here," also gesturing to Ms. Kleiner with his finger. Ms. Kleiner said yes. Councilman Trollinger then began to verbally abuse Ms. Kleiner and appeared to be harassing her in a loud voice by yelling at Ms. Kleiner that she couldn't campaign to a voter. Ms. Kleiner asked Councilman Trollinger what he was talking about. Councilman Trollinger continued by saying, "There is a complaint that you are campaigning to voters," and he continued to insist that Ms. Kleiner could not talk to people. She informed Councilman Trollinger that he needs to talk to all the candidates then because they are all talking to voters. Councilman Trollinger then went stomping inside the polling building with his phone and came back out with a woman believed to be Robin Agnew. They stood across from Ms. Kleiner just staring as if they were trying to bully and intimidate her. Included in this photo is Councilman Trollinger standing with his arms crossed, and he appeared to be furious by his posture. If anyone was intimidating voters, it was Councilman Trollinger, who was verbally assaulting, progressive, loud yelling, and Mrs. Kleiner, who was verbally assaulting Ms. Kleiner, which created a significant aggressive distraction which interfered with the election process. Candidate Stephanie Enoch was standing nearby and witnessed the verbal attack by Councilman Michael Trollinger. This situation occurred in the parking lot, which is clearly outside of the buffer zone. Councilman Trollinger is not a Board of Elections official, and he has no right to verbally attack or harass Ms. Kleiner during the election, nor act to enforce the Board of Elections protocols. Discussion there?
This protest clearly states that this situation occurred in the parking lot, which is clearly outside of the buffer zone. And in my sense, then the Board of Elections is not responsible for behavior outside of the buffer zone. And in that sense, then it does meet the level of probable cause.
I'll second that.
And there's no allegation of how it would have been outcome determined.
Right.
So we can't just assume that we can't just assume these people yelling in the parking lot somehow made an outcome, had an effect on the outcome.
Right. So Doc, you made that in form of motion.
Yes.
All right, I'll second.
All right. Any more discussion? All right, hearing none. All those in favor of the motion to dismiss what we are, I guess, calling the second allegation over the behavior in the voting place parking lot, signify by saying aye. All those opposed? Carries unanimously.
I think it's pretty much got them all.
Yeah, I mean, it appears that the remaining part on page 4 is just to try to bring up what those allegations.
Yes.
Yes.
I can see it.
Everything else is just evidence?
Yes,
Yes.
yes. Statements, yes.
All right. Well, I think we voted on the, maybe be clear here. So we don't get lost in numbering paragraphs. We voted in the affirmative to take to hearing the allegation against the board, against a Alamance County Board of Elections member for improperly
And if you would.
for an individual expression of opinion or support or opposition not intended for general public. Oh, sorry. A violation of General Statute 16339. No individual subject to this article shall make a written oral statement intended for general distribution or dissemination to the public at large, supporting or opposing the nomination or election of one or more clearly identified candidates for public office.
Yes.
No, you might need to state the board member's name.
Board member Dr. Dorothy Yarborough, board chair.
So at this point, do we need to pick a date to have the hearing?
But since we have so many people present, I think that would be prudent if you could make that
All right.
decision, if that's the, agreeable to.
Of course. So there are guidelines on notification and how long we have to have the hearing?
Yes, sir.
What are
According to
those?
general statutes, the hearing must occur within 10 business days from today, not including today. And just a reminder that this coming Thursday is Veterans Day and county offices will be closed. That will not be part of the calculation of dates. So 10 business days from today, but then notice has to be provided at least 3 business days prior to that hearing date. So we're looking at a window of 3 to 10 business days from today.
How about Monday at, say, 10 o'clock,
Well, I don't think that, your calendar is free on Tuesday, is that correct?
Tuesday?
Tuesday morning.
And that would, 3 business days would be tomorrow, Friday, and Monday.
Yeah, so Tuesday morning at 10 o'clock, would that work for you?
Now, tell us about the subpoenas. How, if we subpoena people, how does that work?
The board has subpoena power, much like Congress has subpoena power to call people in and testify and to get evidence to what occurred and what they saw and understand as to the events that occurred.
But if they agree to come, we don't have to subpoena, is that correct? Or is,
Correct. But general best practice is still issue a subpoena just to be sure.
but we have to go through the sheriff's office for that?
I am not sure about that. I need to see if there is a state board of election subpoena
I don't.
provided. So,
Would that be done through our attorney, or do we need to, since we're not representing, I mean, I can write this, up and get it.
I need to
or is
look
that
at the general
something-
statute, but I can provide an opinion later this afternoon just for clarification purposes.
So we've discussed, I think it was proposed on Tuesday at 10.
Yes.
And do we need
We need
to,
to see if our attorney has availability at that.
Yes.
I do.
and as far as subpoena, is that, if the board did decide to subpoena someone, is that something that each board member can individually decide, or that needs to be taken a vote, there needs to be a vote?
I believe the board members can decide that. Because there's not going to be a board meeting convened between now and then to make such a decision. So I would assume that it would be individual board members have the subpoena power.
That being said, do we have recommendations on, would it be appropriate to discuss that now?
If you wish.
Or should we, are y'all interested in discussing that now? It sounds like it is. Okay. Do as much work as we can right now.
Yeah, I mean, my position is it's, I don't think we should take an affirmative step to subpoena anybody here. The party that's moving has just as much power to present their evidence and subpoena who they want in. I don't know who was there, who wasn't there individually, and I don't know what each person's gonna say, and therefore, I don't want this board to subpoena some people and not others, and then give the impression that we're the ones calling the witnesses.
Mm-hmm.
And so my position would be, that we shouldn't subpoena anybody. That it's the moving party's burden to establish this, and that,
Mr. Ryan, I'm sorry to interrupt, but I do have a clarification for the subpoena power. 163, 182.10C1 states, a county board may allow evidence to be presented at a hearing in the form of affidavits, or it may examine witnesses. The chair or any 2 members of the board may subpoena witnesses or documents. Each witness must be placed under oath before testifying.
so that means that at the next hearing, that the moving party that still at that point doesn't have the right to present their evidence and subpoena their own witnesses.
They have that ability to
Okay.
present their own evidence in their
Okay,
case.
okay.
But in addition to that, the board has the power to subpoena individuals.
Okay.
Mr. Chair,
Yes.
I'd like to ask the attorney, if a person is not subpoenaed, can they still be a witness?
Yes.
Yes.
The difference is if they are subpoenaed and don't show up, that's when I mean, I don't know. We can't have a contempt or compel or, but I mean, I guess it would then turn to the state board. I don't know what the process of not honoring the subpoena.
Right, but the fact that a person isn't subpoenaed doesn't mean that they can't be
That's
authorized.
Mr. Homer,
Sorry, I'm asking.
to elaborate on this, the next portion of the general statute, which probably answers your question, reads, the county board may receive evidence at a hearing from any person with information concerning the subject of the protest. The person who made the protest shall be permitted to present allegations and introduce evidence at the hearing. Any other person to whom notice of hearing was given, if present, shall be permitted to present evidence. The board may allow evidence by affidavit. The board may permit evidence to be presented by a person to whom notice was not given if the person apparently has a significant interest in the result of the protest that is not adequately represented by other participants.
Thank you.
And this may be, I mean, a question that you may not be able to answer, but from a hearing standpoint, I mean, what are the rules of evidence? I mean, and so does that mean if somebody's going to be able to come in and testify that the issue, that hearsay, or they have to lay a foundation for evidence? And if you're not prepared to answer that question, that can be something that they can answer down the road. But I guess I'm trying to figure out what rules everybody's playing by.
Again, I can look that up just to be sure.
Mr. Ray has suggested that we do not subpoena anyone. If we did go that route, does public notification fulfill our obligation to anyone who would be interested in seeking to be a witness or to provide evidence?
So I'll give the state statute definition of notice of hearing and then its interpretation. First, the statute. Notice of hearing. The county board shall give notice of the protest hearing to the protester and any candidate likely to be affected, any election official alleged to have acted improperly, and those persons likely to have a significant interest in the resolution of the protest. Each person given notice shall also be given a copy of the protest or a summary of its allegations. The manner of notice shall be as follows. 1, if the protest concerns the manner in which the votes were counted or the results tabulated, the protester shall be told at the time of the filing that the protest will be heard at the time of canvass. Others shall be notified as far in advance of the canvass as possible. Number 2, if the protest concerns a matter other than in the manner in which the votes were counted or results tabulated, the county board shall comply with the rules to be promulgated by the State Board of Elections concerning reasonable notice of the hearing. The state's guidelines says protest hearing must be noticed at least 3 business days prior to the hearing. The notice must be actual notice, meaning notice is actually received in a manner up to the county board, but it must be quickly followed up. But it must also quickly follow any oral notice with a written notice. So if we were to give oral notice today that you intend to have the meeting next Tuesday at 10 a.m., you can announce that to the public today that's in the room, and then also follow it up with written notice to the affected individuals that I've listed off.
Those being candidates or Board of Election members?
The protester, any candidate likely to be affected, any election official alleged to have acted improperly, and those persons likely to have a significant interest in the resolution of the protest.
So that last category is kind of wide open.
Yes, it is. It's wide open to give broad discretion to the
Yeah.
board.
Would you say that it would be the candidates, all of the candidates on the ballot? Because if it's deemed that
Right.
allegation is true, then it could be the outcome of the election.
Right.
I believe that would be the second category, any candidate likely to be affected.
And that would just be essentially all that we would have to notify.
Yes, ma'am.
And would notification via email be sufficient, or would you prefer handwritten?
It's up to the board, any reasonable means possible. Given today's climate and because of the swift turnaround, I think email would be determined to be reasonable here.
And just so I'm clear on my motion, the reason why I feel like our board should use our subpoena powers because it's dealing with allegations made against one of our members. I'm not saying that the board in general, because Ms. Yarborough or Dr. Yarborough may in fact want to subpoena her own witnesses. I guess I'm just saying it'll leave the ones that'll be I guess my motion to clarify would be the ones that are going to be making the determinative decision would not be issuing subpoenas. Does that make sense?
I think so.
Yes.
Because I'm just saying, I don't want to say the board's not going to issue a subpoena and then Dr. Yarborough is going to testify, has evidence she wants to put on and have somebody under subpoena.
Yes.
Okay, good point, good point.
So would we as staff issue that subpoena, or would she be responsible for issuing the subpoena on her personal?
I think that would be a question for the attorney that he's going to, that's why I was asking that question earlier.
According to the statutes, the board chair has the ability to subpoena on her own. And then any two board members have the ability to get together and subpoena on their behalf.
So those are the only people who have the power to subpoena for the hearing?
According to the statute, yes. The county board may allow evidence to be presented at the hearing in the form of affidavits, or it may examine witnesses. The chair or any two members of the board may subpoena witnesses or documents. Each witness must be placed under oath before testifying.
And to be clear, in this case, since the actual board chair has recused herself, would mean that I was the board chair for this purposes?
Yes.
Yes.
But again, the board chair has been, or allegations are against her, so she would have the power to present her own testimony
Yes.
and witnesses.
But not the power to subpoena?
I need to look into that.
Okay. So, as you were saying, Mr. Ray, you're suggesting that the board should not, other than board members and candidates who will be, well, the board should not issue subpoenas, but if we are the only people who can issue subpoenas and an affected party wants to subpoena a witness, how would they do that?
Let me ask you to respectfully drop your motion. Hear me out, if you would.
Sure, and I think I just wanted to clarify.
Yeah.
Does that mean that the moving party does not have the right to subpoena?
When you say moving party, sorry,
Person that filed
the
this.
file,
It does not say under the statute. The subpoena power, according to the statute, lies with the board.
Okay, so I misunderstood. Okay, I removed, I'll withdraw my motion.
Let me, what I'd like to do is make a motion, Mr. Chair, that you and Ryan Ray sit on that committee, the two-man committee. And if it's determined by this board that we want to subpoena, we'll have that opportunity to do so through you two. That's my motion.
But if we're gonna have
Well-
if we're gonna have the hearing Tuesday.
Yeah.
I mean, we need to know today.
Yeah, well,
I mean,
it's
because
kind
it'll
of
have to
quick.
be,
I
it'll
mean,
have to be sent tomorrow.
yeah, well, we can notify, I mean, he's got subpoena power. He can subpoena, as an attorney at law. So, that's one reason I want him on that committee. So we can do that and notify you and let you know who we're subpoenaing. But the board has that responsibility if they want to do that.
But it still has to be within that 3-day margin, correct?
It doesn't clarify in the statute. It just says notice of the hearing, not notice of the subpoena.
Okay.
2 hours.
But if the board wishes to have such a committee, it does have the ability to push the hearing out a few days to allow more time for investigation purposes. Just leaving that out there.
That's the thought.
push.
And let me just speak a little bit about that and getting a subpoena served. In my practice, sometimes can happen in 2 days. And sometimes can happen in 3 weeks.
Yeah.
And so, what I don't want to do is, and for those who aren't familiar, they're not going to go hunt this person down at Walmart. They're going to go they're going to go knock on their door, put a sticker on their door saying, hey, you've got something to come pick up here at the sheriff's department. And that person may or may not feel so inclined to do so. And so we could have a subpoena outstanding at the time of the hearing and it's not been served.
And if the subpoena is outstanding at the time of the
It's not
hearing,
enforceable.
so the hearing would go on without
That's
that
correct.
person.
Is the burden of proof on the protester or on?
On the
person?
protester.
So, they've got to convince you
Yeah.
that when you get to a hearing, without a doubt, that this would have cost an election.
So the board can,
So you don't have to defend yourself.
Right.
They're presenting their evidence to
Right.
you.
so the purpose of the subpoena really is to get somebody who does not want to
That's correct.
Yeah.
provide witness to provide witness.
Yeah.
I would imagine that the Board of Elections members and the candidates who are that's the low bar of who should be notified, if they're interested in providing witness, that they would not need to be subpoenaed to do so.
That's right.
And if someone showed up that wasn't on our list, we can allow them to be a witness anyway, right?
Yes.
It doesn't they don't have to be subpoenaed to be a witness.
Correct. Under the general statutes, says that the county board may receive evidence at the hearing from any person with information concerning the subject of the protest.
So this committee of two, would we,
If needed. Yeah, just have it approved by the board, have it there if needed. And most of these folks, I mean, they're good people, they feel it's a community, and it's not, if you call them and tell them, say, hey, we'd like you to be there, I think that, I don't think it'd be a problem, but, it'd be good to have that if we need it.
so if a member of the, what'd you call them, that filed the
Moving.
protest?
Moving.
The
Moving party.
the moving party or the defense, would we off, if they want to call a witness that they don't think will come, they submit it to the committee, and then we determine whether we should subpoena them or not?
That's what it sounds like to me, which is a procedure that is a little bit contrary to my.
Maybe some conflict there and if, given the situation, a protester asks you to subpoena someone and the board determines it was not going to subpoena them, that's a conflict of interest.
Right, so we're not really turning down, so we wouldn't really turn down the subpoena.
Right.
So we would just be there to give the subpoena if it's
Yeah,
requested.
Yes.
So we make a notification of the option to have a subpoena served. And then if that option was taken by either a member of the moving party or the defense,
Pretty broad.
then it would be two members would provide that subpoena.
And then who bears the cost of this?
But again, this
I'm
is,
sure you can't answer that.
I can't, but the subpoena power lies with the board. And as you stated, the subpoena is there to compel testimony. If individuals have already agreed to give testimony on behalf of a party, then subpoena is not really necessary.
Now, what about subpoenaing evidence? Like there was mention of a tape, a recording.
That can be subpoenaed. It's documents, evidence, recordings, testimony.
Right. And a letter was mentioned, so.
Yes.
Thanks, yeah.
So that information could be subpoenaed, and it also could be presented without a subpoena by a protester or any person that's been called into the hearing. Just to elaborate, might answer some questions from the state guidelines. It says the protester shall submit his or her allegations and introduce evidence. Any other person to whom notice was given may, if present, present evidence. Individuals with relevant information who did not receive notice of the hearing but have significant interest in the protest resolution may also submit evidence if that interest is not adequately represented by other participants.
So at a minimum, we notify Board of Elections members and candidates. And then,
If needed, you know, if somebody said, well, I'm not coming, even if then, if we need to issue a subpoena, which is probably highly unlikely, but it's still good to have a committee in the event we do need to.
All right.
That's where it's coming from.
okay, so we'll create the committee. So we will, notifying board members and candidates, we don't have to vote on that. We do need to vote, am I right?
Notice has to be provided whether you vote or not.
Yes.
to do so.
So really, all we really need to vote on is to create the committee that would be responsible in case the movement party or the defense
Yeah.
decides that they need subpoena power to get a witness or a piece of evidence in.
Yes.
Mhm.
Okay.
And generally, for the general public, when we do something, we make sure both parties have representation, if that makes sense. That's the reason that I selected the two folks that I did to sit on the committee. That way, both parties have representation.
And when you say party, you mean political party?
Yeah, political parties, I'm sorry. So
Yeah.
just wanted you to understand that. What do you think?
All right, well, I'll entertain a motion to create the subpoena committee.
So moved.
Second.
All right, any other discussion? All those in favor, say aye.
Aye.
All those opposed? Motion passes unanimously. I guess we also, are we sticking with our Tuesday at 10 date for our,
That sounds good.
Sounds good to me.
Sounds good.
all right, can I get a motion on that?
So moved.
Second.
Any discussion? Hearing none, all those in favor say aye.
Aye.
All those opposed? Motion passes.
Just for clarification, that will be November 16th at 10 a.m.
Yes, sir.
And we will include the venue at the time of the notice.
Okay, so the venue to be announced.
Yes, because I don't think this will be sufficient space. I'll see if we can
Okay,
secure either county commissioner chair, county commissioner chamber, or the historic courthouse if that's available. I don't know if they've got a trial. Brian, do you know what's going on up there?
On Tuesdays, there's juvenile court. We should be, well, the problem is juvenile court is, kind of a sealed private court, so we may not be able to use that initial entrance. We should be fine.
So for the historic courthouse, we should be fine on.
Oh, you're saying, I thought you were saying the county commissioners are in
No,
the annex.
the historic courthouse.
The only thing they would have would be small claims or,
That's in the basement.
that would be in the basement. And so you're saying use the actual just main courtroom. I don't know if they're having Superior Court or not,
Yeah, okay.
but I can check.
You can, okay, if you don't mind checking,
Sure.
work with Dawn on that.
I can do that.
I'm not sure if they have a video feed. I know,
Oh,
yeah, they must have. Yeah, I forgot the other day.
all right, is any other issues need to come before the board concerning the preliminary hearing for the town of Green Level election?
If we do decide, we'll then reach out to you and you'll draft this, or your office will draft the subpoena, or?
Yes, and I just confirmed the subpoena is the standard clerk of court offered subpoena.
Good.
It's not a special form.
And if I could ask that the board ask that the candidates provide me with a valid email address before they leave here today, please.
Okay.
Is everybody hear that?
Can you repeat that for the?
If any candidates are here, any people on the ballot, would you provide, if you did not receive an email from me yesterday, if you'll provide me with a valid email address, because I did get some bump back. So provide me with a valid email address.
Can I give them a piece of paper to do that on?
That's perfect.
It'll work.
Print it very clearly.
Candidates?
I received an email.
Okay. You want to?
business we got today. Is that it?
I think we had to recount, right?
Do we adjourn?
I think we're about to knock that.
I'm sorry, it's not appropriate for the preliminary hearing.
Absolutely.
Anyone else? Any other candidates?
All lowercase.
All lowercase?
Thank you, Noah.
Yes, ma'am. Well, I think we have finished item number 3 on the agenda. And we are ready to move to number 2 on the agenda. Are we now ready to move to number 3? Board conducts recount of town of Green level elections.
Okay, you want to recess just for a minute, because we'll have to get Staley.
Okay.
and
Can I get
Joseph
a motion
together
to
with
recess until Staley returns?
So move.
Second.
All right, all those in favor? Aye. Motion carries.
Should
Thank
be
you.
15 minutes, maybe.
This meeting is now recessed until